Good afternoon, everybody, and welcome to our Global Data Hub webinar this afternoon. Those regular people who dial in may have noticed that we haven't got Vin's dulcet tones today. I'm Paul Glass, partner in the Disputes and Investigations team at Taylor Wessing, and I'm standing in for Vin, who's obviously our head of data protection team today. For those who I haven't spoken to before, I head up our UK cybersecurity practice. So today's webinar is part of our regular program where we bring you our expertise and views on data protection issues, and these webinars sit alongside the content on our Global Data Hub, which is our main resource for all things data protection related. Now, for those of you who haven't gone onto the Global Data Hub recently, we have recently launched the new redesigned version of the Global Data Hub, which is a significant improvement on the previous version. It's faster, it's easier to navigate, and to find the content that's relevant to you. So if you haven't been on to the Global Data Hub recently, please do take a look. We also haven't done a webinar for a little while because of a small piece of legislation that came into effect on the 25th of May, which has been keeping everybody fairly busy. Content on webinars and the Global Data Hub has been focused on everything GDPR for some time now. So as you work through your GDPR compliance programs, please do take a look, as previous webinars and content are still available on the new version of Global Data Hub. So today's theme is looking at issues around cybersecurity, because we haven't done a cybersecurity webinar for a while, so we thought it was time to revisit the topic. Quickly, a little about Taylor Wessing, for those of you who don't dial in regularly. We're an international law firm across all the jurisdictions that you can see on the map there. We act for a range of leading clients in local and international markets, providing a full-service law firm offering. And as you can see from the map, our office footprint spans across Northern, Central, Eastern Europe, Middle East and Asia, and also our representative offices in the US. And we provide data protection advice across all of those offices. So today's webinar is brought to you by the Taylor Wessing data protection team, with the reputation management practice also involved. As you can see from the slide in front of you at the moment, the team advises on all aspects of data protection and information law, and that's a global 22 partner team. And that's complemented by our international network of privacy specialists to provide a sort of global one-stop shop service for all things data protection. I mentioned before the revised version of Global Data Hub, so I'm not going to say any more on that, but that's just showing a bit more about what the new version of it looks like, so please do take a look at it. This has been up for a while, but just mentioning it in passing as we haven't had a webinar for a while. We do have our Global Data Protection Guide, which is a comparative guide to data protection laws across over 65 countries, and that allows you to ask a question across either all the countries, or look at a range of issues for a single country, or compare specific issues across selected countries. And it's a very useful tool for getting an initial view on issues relating to data protection across many different jurisdictions. So what are we covering in today's webinar? Debbie is first going to look at breach reporting issues under GDPR and NISD. I'm then going to do a bit of crystal ball gazing as to what we can expect from the ICO on enforcement under GDPR following data breaches. Michael Yates, who's next to me, who's a senior associate in our reputation management team, is going to look at issues around data breaches and reputation management. And I'm then going to talk again about data theft and sort of fighting back against unknown hackers. And that last section from me and Michael's talk follow on from a matter that we acted on for a client a few months ago, where we combined sort of data protection and sort of traditional privacy injunctions to get a very good outcome for a client who had had a significant amount of data stolen by hackers. But more on that later. I'm going to hand over first to Debbie. After the presenter bios even, I'm going to hand over to Debbie to speak on GDPR and breach reporting under NISD.
Thanks, Paul. Right, I'm going to start by outlining the new breach reporting provisions introduced last month, both under the GDPR and the Network and Information Systems Directive, or NISD. Both these pieces of legislation deal with cybersecurity requirements and breach reporting, but there are significant differences. The GDPR covers obviously personal data, and that's data which can identify an individual, but NISD has a different objective to the GDPR. Rather than focusing on the security of the data, the personal data, it deals with the security of network and information systems, so it's much more focused on infrastructure. NISD is a minimum harmonisation directive, and that means that not only do member states have to produce implementing legislation, they also have discretion to go above and beyond what the directive says. And that means we're looking to a certain extent at fragmented implementation across the EU. But if you are a multiple jurisdiction company, you can take comfort from the fact that you'll be regulated in the place of your main establishment. Just worth mentioning that the UK's implementing legislation is the Network and Information Systems Regulations, and I'm going to be talking about those when I'm talking about NISD. It'll be through the prism of UK compliance. Paul's going to look in more detail at the general cybersecurity obligations shortly, so I'm going to focus on breach reporting provisions. But before I do that, let's look at who the legislation applies to and what's meant by a data breach. So the GDPR applies to data controllers and data processors. There are direct security and breach reporting obligations on both those who control data and those who process it on behalf of the data controllers. This is much narrower in scope. It applies to operators of essential services, or OESs, for example, utilities, and each member state defines its own OESs. It also applies to digital service providers, or DSPs, and this covers online marketplaces like Amazon, online search engines like Google, and cloud service providers like Amazon Web Services. Where sectors are subject to sector-specific union legal acts relating to information and network security, those actually take precedence. So, for example, NISD does not apply to telecoms providers, as their security is dealt with by the Framework Directive. Both the GDPR and NISD are intended to have some extra EU application. The GDPR applies not only to those established in the EU processing personal data, but also to those targeting EU citizens with goods and services, or those monitoring the behaviour of EU citizens. And NISD will apply to DSPs which are established outside the EU, but which offer services within the EU on more than an incidental and passive basis. So what exactly is a breach for the purposes of these pieces of legislation? The Article 29 Working Party, which has now become the European Data Protection Board and is comprised of regulators from across the EU member states, has given guidance on this and identifies 3 types of breach under the GDPR. And some breaches obviously engage one or more of these elements. So you can have a confidentiality breach, which is unauthorized or accidental disclosure of or access to personal data. An integrity breach, which would involve unauthorized or accidental alteration. Or an availability breach, which will be accidental or unauthorized loss of access to or destruction of data. And that includes, for example, a power cut, which causes systems failure. All breaches have to be recorded alongside the decision-making process engaged to decide whether or not the breach is reportable. Now, for the purposes of NISD, a breach is much more related to interruption of service, and it's defined as being any event having an actual adverse effect on the security of network information systems. So, in the UK, the ICO is a data protection regulator. And the ICO also helpfully regulates DSPs for the purposes of NISD. But OESs are regulated by the relevant competent authority, and this is sector-specific and set out by each member state in their implementing regulations. As Paul's going to discuss in more detail, the regulators do have significant weapons in their armoury, and much has been made of the maximum fines which can be imposed for non-compliance. It is worth reiterating the worst-case scenario, and I'm going to do that in a minute, but do remember this is the nuclear option, and it won't be used lightly. Sanctions for non-compliance of breach reporting provisions under the GDPR can be up to the higher of 4% of annual global turnover, or €20 million. But a data breach can trigger more than one provision of the GDPR, and fines can be cumulative, although they will be limited to the higher applicable bracket in relation to a single incident. A data breach may, for example, incur the highest level of fines in relation to related failure to take appropriate technical and organisational measures, and also the lower level of up to 2% of annual global turnover or 10 million for failure to make the appropriate breach notification. In addition, as if that weren't enough, sanctions under NISD can total 17 million in the UK, and that may vary from state to state, as member states do have some discretion there. There are two categories of breach reporting requirements broadly, reporting to the regulator and reporting to individuals. So let's start with the GDPR reporting requirements to the regulator. In terms of breach reporting to the regulator under the GDPR, data controllers are required to report a personal data breach to the competent regulator, who's usually referred to as the supervisory authority or the SA, without undue delay and, where feasible, not later than 72 hours of becoming aware of it, unless the personal data breach is unlikely to result in a risk to the rights and freedoms of data subjects. So we're looking at quite a narrow period of time, 72 hours, and if a notification is made after that period, the data controller will have to justify why there's been a delay. Article 29 Working Party has put out guidance suggesting that the point at which the data controller becomes aware of a breach is when they have a reasonable degree of certainty that a security incident leading to a breach has taken place. And this does mean that there may be a short period of investigation during which the controller is not regarded as being aware and before the clock starts ticking. But once a data processor becomes aware of a breach, conversely, they have to inform the data controller immediately, and the data controller is deemed to have knowledge. So it's very important that controllers ensure their data processors are contractually obliged to inform them of any breach immediately. When a data controller notifies the regulator, the notification has to include at least a description of the nature of the breach, including, where possible, the categories and approximate number of data subjects and personal data records concerned, the name and contact details of the relevant data protection officer or contact point, the likely consequences of the breach, and measures taken or proposed by the controller to address the breach and mitigate its effects. Now, obviously, precise figures may not be available so early in the game. So the Article 29 suggests that tiered notification may be appropriate where it can be justified, and also that batch notifications can be made where the same information is involved. The guidance is also helpful on advising organisations which supervisory authority to notify. They should identify their lead SA as soon as possible, and if a reportable breach occurs, the organisation should notify the lead SA where there is one. If there isn't a lead SA, notification should be made to the SA where the breach has taken place. But the Article 29 Working Party also recommends that SAs in affected member states should also be informed. If an organisation doesn't want to do this, it should at the very least provide its lead SA with a list of member states where data subjects are affected by the breach. Under NISD, OESs have to notify their competent authority of incidents having a significant impact on the continuity of the service they supply. Timing provisions here are pretty similar to those under the GDPR. Notification has to be made without undue delay and within 72 hours in the UK. And the notification has to include enough information to allow the competent authority to determine any cross-border impact of the incident. To assess the nature of the incident, the number of affected users, the duration of the incident, and the geographical spread of its impact must be taken into account. The competent authority will then inform the Computer Security Incident Response Team, or CSIRT, as soon as reasonably practicable. DSPs have slightly different provisions. They have to notify incidents having a substantial impact on the provision of a service to the ICO. Notifications have to contain enough information to allow the ICO to determine the significance of any cross-border impact. Whether or not an incident is substantial has to be assessed in accordance with the criteria in a separate regulation, which also sets out elements to be taken into account by DSPs for managing network information security risks. In determining the impact of an incident, the number of affected users, particularly those relying on the service to provide their own services, the duration of the incident, its geographical spread, and the extent of the disruption to the service, and the economic impact must be taken into account. Where an OES relies on the service provided by the DSP, the OES also has to be informed. There's no obligation on OESs or DSPs to report a NIS incident to individuals, but the public may be informed of an incident by the competent authority or the CSIRT, and it is possible that DSPs may be required by the ICO to make that notification to individuals themselves. Now, this is quite different under the GDPR, where a personal data breach is likely to result in a high risk to the rights and freedoms of a data subject. The controller has to communicate the breach to the data subject without undue delay, and this really does mean as soon as possible. This is a higher threshold to meet than the reporting requirement to supervisory authorities. We're talking about a high risk, not just a risk. But it does mean that it's possible a breach may need to be reported to the supervisory authority, but not to data subjects. Where a breach is reported to the supervisory authority and not to the data subject, it is possible that the regulator will then require the data controller to notify data subjects. There's no requirement to make a notification to data subjects where any of the following conditions have been met. So where technical and organisational measures have been applied to the personal data to make it unintelligible to an unauthorised person, so for example, because the data is encrypted, or where the controller has taken steps to ensure the originally high risk is no longer likely to materialise, or where to notify each data subject would involve disproportionate effort, in which case you can use a public communication or other method of information which would inform the data subject in a similarly effective manner. Now, there are also requirements around what the communication, how the communication must be made and what it should contain. So it has to describe in clear and plain language the nature of the breach and contain at least the name and contact details of the relevant data protection officer or other contact point, the likely consequences of the breach, and any measures taken or proposed to address the breach and or mitigate its effects. The Article 29 Working Party underlines that transparency is key, and as with so many things under GDPR, you've got to make sure that people understand what you're doing. So that includes using appropriate language, and you may also need to use more than one type of notification depending on the intended audience. So while in theory every affected data subject should be notified individually, where this involves disproportionate effort, you may be able to use group notification, but that shouldn't take the form of a press release or corporate blog. The notification has to be active and may have to be made through multiple avenues. It's also worth mentioning here that data processors also have breach notification obligations under the GDPR, and they have to notify their controllers, as I mentioned earlier, of a personal data breach without undue delay, and that effectively means immediately. So the controller-processor contract should make provision around that. So what does this mean for businesses? Well, the emphasis placed on the data controller's ability to assess the situation under GDPR is to be welcomed, but as with all legislative requirements which include flexibility, this also introduces an element of doubt as to when a data breach poses sufficient risk to require notification. And we also expect to see different supervisory authorities in different member states take different approaches as they have done historically. So despite the fact that the GDPR is bringing in a lot of harmonisation across the EU, we're still expecting to see differences in attitudes of regulators. So the best way for organisations to deal with this is, of course, to minimise data breaches, but also to have policies in place to enable staff to assess risk and to be able to demonstrate compliance. And this should sit alongside a breach response plan so that it's entirely clear what procedures should be followed in the event of the breach. As with so much of the GDPR, being able to demonstrate that the proper precautions and steps were taken will be key. And please do refer to the Global Data Hub for checklists and more information about steps to take. And now I'm going to hand back to Paul.
Thank you, Debbie. So I have the task now of speculating a bit on data breaches and enforcement under the GDPR. Obviously, we are less than a month into the GDPR world. Contrary to some speculation, the sky hasn't fallen yet. We're all still here. And so we're a long way from any enforcement action by the ICO. But there have been a number of breaches notified to the ICO. Unfortunately, some of our clients have had incidents that we've had to notify, and there are some other ones which may have been in the press a week ago, which have been notified. But this is sort of a bit of a look at what's out there at the moment and how we think the ICO will approach the question of enforcement for following data breaches. So Debbie's covered the reporting obligations on the GDPR. There's been a lot of noise for quite a while about the quantum of fines under GDPR. A lot of people saying, oh yeah, emphasising the maximums, 4% of global turnover. Whichever way you look at it, these are significantly increased fining powers from the previous cap. But we don't expect to suddenly see significant numbers of very large fines. And in fact, the ICO themselves have said that. I'll come on in a bit to sort of some of the statements by the ICO. Looking very briefly initially at the sort of core obligations in relation to security under GDPR, what was Principle 7 is now Article 5.1F, which requires that personal data shall be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction or damage using appropriate technical or organizational measures. The eagle-eyed of you may have noticed that's changed by one word from Principle 7, in that Principle 7 said using appropriate technical and organizational measures. In reality, I don't think that's really going to make too much of a difference. We then go on to Article 25, which is data protection by design, and this mandates that at the time of the determination of the means of processing and the time of processing itself, organizations must put in place appropriate technical and organizational measures designed to implement data protection in an effective manner and to integrate the necessary safeguards into processing. You then go on to Article 32 as well on security of processing, which sets out specific obligations to put in place appropriate technical and organizational measures to ensure a level of security of both the data processing and the processing environment. Now, you may have noticed that in relation to Articles 25 and 32, I haven't sort of stated precisely what the article says. The language I've used there is taken from the ICO and National Cybersecurity Centre guidance that was published on the 18th of May, and I'm going to come on to that more in a minute. And you'll see at the bottom of the slide, I've said those requirements should be interpreted consistently. Hopefully there will be, but we'll have to wait and see. So, just picking up now what the ICO has been saying, and there have been various statements either on ICO blogs or statements from the Commissioner, Elizabeth Denham, at conferences in the run-up to the 25th of May. And these look at the issues from a number of perspectives, but have sort of common themes running throughout them. First theme is that the Commissioner has been keen to emphasise that there are a number of options in the regulatory toolbox, not just fines. There's been an awful lot about in the press, in marketing, about the level of fines, but the Commissioner has said, been keen to refer to negotiated resolutions, undertakings, compulsory or voluntary audits, enforcement notices which require a data controller to take certain steps, and yes, monetary penalty notices, or as everybody refers to them, fines. But the message here is very much, look, this isn't going to be a world where the ICO is suddenly fining everybody where previously they wouldn't have been. Second, the Commissioner has also stated that the ICO's approach to enforcement will remain the same under GDPR as it was under the Data Protection Act 1998 version. Query whether this is in reality practical or not. As a matter of theory, that may well be the case. But post-GDPR, the ICO is going to be notified of significantly more breaches than it was before. And this means it's got more information at its fingertips as to what is going on in the market, good, bad practice. And our view is it's likely that its approach will change based on that additional information, whether deliberately or not. So picking up the Commissioner's comment that fines aren't the only thing out there, she's also been keen to say that, the quote, hefty fines will be levied for organisations that persistently, deliberately or negligently flout the law. Now, what that actually means in practice, we'll have to wait and see. there is obviously one organisation who may have been on the front page of the news last week as having a significant data breach in the UK only 6 months after they were on the receiving end of the joint largest fine that the ICO has raised to date for a Principle 7 breach. Now, luckily for them, it appears that the incident took place in July 2017, or at least started, so pre-GDPR. And obviously there's little in the public domain as to what actually happened on that incident. But query whether that's persistently flouting the law. We don't know yet, but that is the kind of thing which I imagine the ICO will take a rather dim view of. One theme that runs through the Article 5.1F, Article 25, Article 32 is this reference to appropriate technical and organisational measures. So just looking briefly at that, and this has to be a quick run-through in the time we've got. I referred before to the ICO Guidance, and this was produced in conjunction with the NCSC, the National Cybersecurity Centre. It's published on the 18th of May 2018. It's very easy to find on the ICO and NCSC websites. It's only 7 pages long if you print it, so I would definitely recommend having a look. It does refer early on to outcomes-based regulation or outcomes-based guidance. Those of you who are regulated by the FCA may be familiar with that. People have differing views on what that means in practice and whether it effectively allows the regulator to retrofit what happened to the outcome. We'll have to see on the ICO's approach to that. What the guidance does say is it refers to Articles 5.1F, 25 and 32 and then states that these turn what is considered good security practice into a legal minimum. Now, the problem is, if you look at the guidance, it's not really clear what the legal minimum is and what good security practice is. That is still sort of at the discretion of the ICO, effectively. So we'll have to see where that comes out in the future. The guidance sets out certain principles, and for those of you familiar with security around data protection, these won't be surprising, but I would recommend reading them in a bit more detail in the guidance. There's reference to minimization of personal data collected, managing, limiting and controlling access to that data, protecting the CIA triad, which Debbie referred to, confidentiality, integrity and availability, resilience of processing systems and ability to restore availability of personal data, and regular testing of the effectiveness of systems. The guidance then makes it clear there is no one-size-fits-all approach, and that's hopefully goes without saying. An organisation that is a sort of relatively small e-commerce retailer holding names, address, delivery address, phone number, using third-party payment processor and iframes so the credit card data never touches their systems, is going to have different risks, well, different data they hold and different data risks relating to that data to a healthcare provider or a FTSE 100 company holding large amounts of personal data. But the guidance does refer to 4 primary outcomes, and there's sort of a heading under each, and then sort of subsections which the organisation should consider. And I've listed those on the slide there. I'm not going to run through all the subheadings, but broadly the outcomes are managing security risk, protecting personal data against cyber attack, detecting security events, and minimizing the impact. So it's not just about putting in place systems and controls to prevent access to data. It is about detecting when there has been access and then minimizing the impact afterwards. There is reference, obviously, to having regard to the state of the art. That got a lot of excitement when it was first put into the draft of the GDPR. It doesn't mean you have to have state-of-the-art security in place. It means that in considering what security, technical and organisational measures to put in place, having assessed the risk relating to the data you hold, you have to consider, well, what is possible, what is the best that could be achieved, and then put in appropriate measures. I've got a bullet there saying, referring to some articles of poor practice that we've seen on breaches. They're set out in the article in this month's Global Data Hub. So if you do want to see what we've seen things that the ICO get particularly exercised about poor practice, then please do take a look at that. So sort of summing up really, we've got to have the ICO to have, we've got to expect the ICO to have reference to its 18th of May guidance. That is the guidance it has put out, it has promulgated on security. The key here, as Debbie highlighted, is having processes for assessing risk relating to data, for risk assessment, understanding the risk that the data you hold poses, and putting appropriate security measures in place relevant to that data, and that's technical and organisational measures. Continual testing and assessment is important. Not every day, but you do have to have a documented process for saying, okay, we put in place these technical and organisational measures however many months ago. Are they still appropriate? Do we still have the data we thought we had then? And having that ongoing process of understanding what the risk is. Demonstrating compliance is, as you all know, key under GDPR. So actually having that record of undertaking the risk assessment, and this is why we did X, Y, Z. The breach log may become significant. We do expect the ICO to start asking for copies of breach logs, maybe not when every breach is notified, but certainly for any breaches that they want to investigate. We do expect to see escalation of response from the ICO for repeat offenders, and that's picking up the comment earlier about persistent offenders. We do expect there to be more fines, purely, at least if only, because of the fact that more breaches will be reported. Not necessarily as a sort of percentage of the overall number of breaches reported to the ICO, but because the threshold, there is now a strict obligation to report where the criteria are met, we do expect that there will be more fines. And obviously the last point is picking up Dixon's car phone. They have had two major breaches. Both appear to be pre-GDPR, but they are a well-resourced FTSE 250 company, so query whether that is the kind of situation that the ICO might look to penalise more heavily than it otherwise would have done previously. I'm now going to hand over to Michael to talk about data breaches and reputation management.
Good afternoon, everyone. My name is Michael, and I'm a Senior Associate at Taylor Wessing, and I specialise in reputation management issues for individuals and companies, and I work with Paul on cybersecurity and data breach cases. I'm going to talk about the new challenges to protecting corporate reputation following a data breach. Like a corporate wrecking ball, a data breach, as we know, can take many forms, be it a cyber attack, a technical fault, a lost laptop, employee leaks, or a reply-all email, and it can take place within as well as from outside an organisation. Suffering a data breach can cause immeasurable damage to a company's reputation and can damage brand, public perception, customer trust, future comms strategies and advertising, regulatory record and share price, and it can even destroy a company entirely, as we've seen recently. 2018 sees a new set of emerging factors causing greater challenges to protecting a company's reputation following a data breach, and I'm going to address 5 of those. The first one is dealing with the media directly, and the other 4 highlight all the different avenues by which information about a data breach can enter the public domain and could lead to damaging stories in the press. It's therefore very important to consider all of these potential avenues during the lifespan of a data breach in order to manage reputational risk. So challenge number 1, greater media scrutiny. And the media is taking a greater interest in what companies do with data, be it profiling or harvesting data or using it for online advertising. Data breach stories will only increase as more companies are caught by the GDPR and obliged to report. And these stories often relate to other big news story areas, such as consumer protection issues, politics, social media, and online retail. But the press may not always get the story right. And false allegations published may be defamatory of the company and cause damage. And false allegations, unless challenged, can live online forever and can have long-term effects on a company's online reputation. So the best time to influence or stop a false media story about a company is prior to publication, when first approached. But time is often very short, as journalists often provide very short deadlines for responses to their questions ahead of publication. So to get ahead of a false allegation story or a potentially defamatory story prior to publication or broadcast, a company should take various steps, and I've set some of them out on the slides and I'm going to go through those now. So the first one is to appoint a team, including reputation management lawyers, and prepare a legal and communication strategy in parallel to deploy in a crisis. This must involve establishing the facts around the data breach and taking careful advice on pre-prepared reactive statements. Decide on whether a dual legal and communication approach is required. You may need different approaches for different situations. Note that it will almost always be impossible to obtain an injunction to stop the publication of defamatory allegations because of the law, whereas it is possible to obtain an injunction to stop the publication of a company's confidential information. Those are two quite important distinctions. Tackle a threat to publish false allegations by taking a legal approach to explain why the allegations are false. You must also explain the financial damage that publication would cause, as companies must prove that under Section 1 of the Defamation Act in order to have an actionable claim and therefore a credible threat. Also explain the legal consequences of going ahead with false publication in order to apply legal pressure to the publisher to try and make them back down. If that doesn't work and a story breaks containing false and defamatory allegations, consider circulating a legal notice explaining the falsities to other media to stop wider republication of those same allegations, or issue a reactive press statement to counteract a misleading story and any damaging narrative growing on social media. And lawyers and PR specialists often work very closely together on those issues. An approach to the original publisher for a correction, clarification or apology, or if possible the removal of the online article, should be made as soon as possible. And if they refuse, take advice on the merits of threatening legal action. If the publisher is regulated, and as an alternative to legal action, consider making a complaint to IPSO or Ofcom if it's a broadcaster, on the basis that the story is inaccurate, in order to similarly try and get it removed and a clarification published. If anyone has any other questions about those steps, feel free to follow up with me after the webinar. Challenge number 2. Greater parliamentary scrutiny. Now, the Cambridge Analytica Facebook data breach allegations have seen governments in multiple jurisdictions intervene in a data breach issue, with high-profile appearances from Mark Zuckerberg and Alexander Nix in recent months. Therefore, it is essential to try and correct the public record if it contains false allegations, as they can often become the basis for questioning at public hearings before officials, all of which are reportable by the media under the protection of privilege. So by way of example, in the UK, the Digital Cultural Media and Sports Committee's inquiry into fake news has created a free and privileged source of media coverage for the press. And here are some comments about those types of sessions. Witnesses can be summoned to public committee sessions before a number of MPs and held in contempt if they fail to attend. Many summons turn up, but some don't. MPs can ask unfiltered questions without any notice of what they will ask, and questioning is usually broadcast online and reported live. False allegations made during sessions are protected by parliamentary privilege and fully reportable, as I've said, without legal consequences, unless what is published is unfair or inaccurate. Therefore, it's essential to monitor the coverage and correct inaccuracies made by the media. Uncorrected information in the public domain can, as I've also said, become a basis for questioning and can often lead to a company reliving a crisis again during the session. Preparation for sessions is essential. Witnesses must not knowingly mislead, otherwise they will be held in contempt of the House. Opening statements can be submitted by those being questioned, which can help to ground questioning later by MPs and the company's position. The result of all this is that those questioned are effectively defending their company's reputation in real time, but can often offer to come back to the committee later on in writing on a particular point if the information to answer a question is not immediately to hand. However, these sessions can be particularly potent to corporate reputation, but can also be used to set the record straight. Moving on to challenge number 3. Cyberattacks, blackmail and police. Data-rich companies are key targets in an ever-increasing spate of cyberattacks, which often involve a demand for money in exchange for the return of stolen data. The companies which refuse to pay the demand are fighting back. See 2 recent cases on the slide, which Paul is going to talk more about later. In these two cases, very briefly, a hacker threatened to publish or sell confidential information taken in a cyber attack unless a ransom was paid. The companies refused, potentially creating a massive reputation risk if the hacker followed through with the threats. And both companies applied to court for injunctions against the hacker to restrain the threats made from being carried out. Now you may ask the obvious question, what use is a court order against a hacker? And the answer is that if the hacker carries out his threats to publish, the order can be served on those platforms that he or she uses to procure takedowns, thereby shutting down all the legitimate routes used by the hacker to damage the company and cutting off circulation in the hope that he or she gets bored. Now, taking legal action in open court proceedings can obviously create a story for the media in itself, as the proceedings are open and reportable. This can create a deterrent from a company potentially taking action. However, a company can take action under the protection of anonymity, i.e. where initials which do not identify the company are used during the court process instead of its real name. This happened in the PML case, where the judge granted anonymity because the company was a victim of blackmail, and these types of protections can allow companies to take action and protect themselves without themselves becoming the story. It's also important to remember that police investigations often run parallel to civil actions or forensic investigations by cybersecurity experts, because this can create another dimension whereby information about a breach can enter the public domain. For example, if a hacker is caught and prosecuted, information could come out as part of any criminal proceedings or trial, which will then lose any private or confidential qualities and be fully reportable by the media. Therefore, if the company is involved in a parallel police investigation in relation to a cybersecurity attack, consider whether it's appropriate to apply for reporting restrictions to prevent disclosures under the Contempt of Court Act to protect the company or witnesses or victims of blackmail during that process. Challenge number 4. Data subjects' rights and civil actions. As already discussed, the GDPR creates new and enhanced rights for data subjects, enabling them to better control their data, and see a couple of them listed on the slide. A company's alleged failure to comply with data subjects' rights can lead to a number of reputation risks. Adverse press coverage and stories can arise via a number of routes, including social media. For example, a data subject, having been informed by a company about a data breach, may seek to enforce their rights and become disgruntled and take to social media to publish allegations about or directly to a company's social media account, which can then be picked up by and made mischief of by competitors. If a number of disgruntled data subjects take to social media to make allegations, it could become visible to the media, who may follow up with them in order to prepare a story. Journalists may then approach the company for comment, as I've already covered above. Failure to comply can also expose a company to civil claims and for damages, potentially on a collective basis by a large number of disgruntled data subjects. And these collective actions against companies are likely to increase as the cost of litigation can be pooled and evidence, knowledge and litigation risk can be shared. If defended, a live claim would enable the media to then obtain documents containing potentially defamatory allegations made about the company by the claimants, the fair and accurate reporting of which is again protected by privilege. Ultimately, a court case which goes all the way to trial will allow the media to report on the progress of that trial on a daily basis, potentially creating days of prolonged and damaging media coverage, and will result in a public judgment at the end of the day in favour of or against the company. The recent case of various claimants v. Morrison's is a prime example whereby over 5,000 employees and former employees sued for breach of the DPA, and the judge held that Morrison's were vicariously liable. Liability in these cases, aside from any regulatory fines under GDPR, could have serious financial impacts if a number of data subjects, a large number of them, are ultimately entitled to compensation as a result of such claims. And lastly, challenge number 5, regulator scrutiny and data subject notifications. This last challenge concerns what steps the regulator might take following a data breach after a company reports this to the regulator, as well as notifying the data subjects involved. These two obligations carry obvious reputational risks. Firstly, there's a new obligation to report data breaches, as we've already discussed. And it's unclear whether reporting itself will trigger a statement made by the ICO, but breach reporting could trigger a regulatory investigation, meaning that a decision or penalty notice could be published, including details of the breach, failures by the company, and sanctions. The ICO is potentially likely to seek publicity over new enforcement actions taken post-GDPR, and decisions, press releases, and notices published via its website are fully reportable by the media, again under the protection of privilege. Therefore, breach reporting and subsequent investigations are another way in which information can enter the public domain and ultimately find its way into the newspapers. We therefore recommend trying to manage the outcomes of those investigations, or better still, taking proactive steps to prevent rather than cure a breach. Secondly, companies may also have to notify data subjects affected by the breach unless various conditions are met. See the slide. Therefore, and as I've already discussed earlier, disgruntled data subjects, in relation to notifying them, companies should seek advice on decisions to notify, as once it takes place, the fact of the breach and its details have arguably entered the public domain, and it is also more likely that they will come to the attention of the media. This can lead to potentially adverse press coverage before any official investigation or decision by the regulator has taken place. This can result in, again, media inquiries being made and needing to be dealt with in the way that we've addressed above. Thank you very much for listening, and I'll now pass back over to Paul, who's going to talk about data theft and companies fighting back.
Thank you, Michael. So this is just picking up in a little more detail some of the issues that Michael raised with talking about the injunction obtained and the use of that. And this is a matter that we worked on together for a client a few months back. And this is perhaps one that it's not immediately obvious in this situation that civil injunction is an appropriate thing to do, or even that it's available. Briefly sort of setting out what happened, as Michael sort of mentioned, it's an ongoing series of attacks believed to be by an organised crime group against a number of companies in the UK and across Europe, and they obtain access to company systems via a number of different potential methodologies, and they basically sit around, watch how data moves, navigate the IT systems a bit to work out what's there. They then exfiltrate significant volumes of data, and shortly afterwards the directors of the company will typically get an email saying, we've stolen all your data, here are a few sample documents attached, and here's another way of verifying that we've got your data. Unless you pay X million in Bitcoin by whatever date, we will release all the data. If it's a listed company, your share price will be destroyed, all your confidential information will be out there, all your dirty laundry is out there. Which, depending on the company, depending on what's stolen, presents a significant risk. Now, this type of injunction has been used for a while in relation to blackmail cases, typically in the sort of more private privacy sense. But the Clarkson's judgment that Michael referred to was the first well-known one use of it in this area. In that case, anonymity wasn't available all the way through for various reasons. We then followed that with our client with the other judgment in PML, which Michael referred to, and there have been one or two others since, where other victims of this type of attack have obtained a similar injunction. And the order itself is sort of broadly a non-disclosure order requiring no publication of the data with a penal notice attached. So breach of the order is a contempt of court, and also a requirement that anyone who's put on notice of the order must comply with its terms. And that's the very important point that Michael made earlier about effectively cutting off the route to market for the hacker in making good their threat to publicise. One other important point to pick up here is that usually these types of incidents are international in nature. The data is unlikely to be hosted on a file server in the UK or a web host in the UK. You'll fairly often have some information as to where it is in fact being hosted, or where it appears to be hosted, I should say. So, and you can work out where that IP address is easily enough. So you consider whether you can also get similar injunctions or helpful supporting injunctions in other jurisdictions. And in the case that we were involved in a few months ago, we were able to identify the jurisdiction in which it appeared the data was hosted and obtained a supporting injunction before the courts in that jurisdiction, which was served on the web host at the same time. One other point which I'm not going to talk about in any detail because time constraints, if there is information as to where, at least some information as to who's involved, or a corporate identity or a location where activity is taking place from, then if it's in the UK, a search order is another option in terms of without notice applications to either obtain evidence or seek to recover data. And that's something that we've used a number of times in the past. This was just a sort of the next email, sort of a short description of the type of attack. I've already gone over that, so I'm not going to cover that in more detail now. And again, this is sort of pointing out a bit why the civil injunction. I've talked about most of the points on this slide already, but there's one point which is very important in actually making use of the injunction properly and cutting off an attacker's route to market. And that is the ability to actually monitor where data can be published. And there are a number of companies that provide this service now. There's a particular one who we work with because we've known for a number of years. And the way those companies operate is that the client, the victim, provides them with a seed data set effectively, which should then enable them to identify publication of the data which has been stolen. And they then monitor in real time the dark web, the deep web, and the clear web in an attempt to identify when the hacker tries to make good on his threat of publication. And that will typically be something like posting on, let's say it's a listed company, on investor forums, or if it's a private, or just using social media, with links to a file sharing site in another jurisdiction which will have some of the stolen documentation on it. So the company that you use to do that sort of effectively alerts whenever it becomes aware of an attempt to publish the stolen data, and then we literally serve or put on notice web hosts, data center, social media company, whoever, of the order which has been obtained. And usually, if it's a European, US company, they tend to comply with those orders. Now, if it's a social media company in Russia or a web host in Russia, query whether they would comply. We have actually had some success in getting compliance with those orders in jurisdictions where you might not necessarily expect them to comply. So that's just sort of a very brief run through the option that is available if you are a victim of that kind of data theft and ransom. It is an evolving area of jurisprudence, but it is one which is being used more and more now, and is a good way for companies to be able to fight back in a situation where it might not be immediately obvious how to do so. I just wanted to move on quickly now, because we had, in the usual way, some polling questions at the end. The first of those is, if you had to report a data breach to the ICO, are you concerned about the status of your GDPR compliance program and the risk of an investigation broadening out into other areas? Typically, when you report a breach, if the ICO is interested and wants to take it further, they will ask for policies, they'll ask about systems and controls. So there is a risk of an investigation broadening out further. And if people can answer that, either sort of yes, no, or maybe answers to the question. So I'll just give a little bit of time for people to answer that, so that get some information on that. We're not going to have time for questions generally, but I did want to just pick up on one question which somebody put in, which is whether GDPR will only apply for breaches occurring after the 25th of May, because I obviously made reference to the Dixon's car phone earlier. The position's not entirely clear on that. Our view is that in terms of the actual systems and control failure, the Principle 7 or Article 5(1)(f) failure, if there is one, the better view is that the ICO should apply the law that was in effect at the time of the breach. But there are obviously other potential fines which can be raised post-GDPR, which may relate to ongoing failures in relation to the same incident. So the position isn't 100% clear at the moment. We'll have to see how that plays out. But certainly it seems difficult to us to argue that the fining regime in relation to a breach which took place before that fining regime was legally effective, that seems to be fairly difficult for us to argue. So moving on to the second question, which is, are you comfortable that you have appropriate processes in place to ensure that a possible breach is identified and escalated within the business to be able to comply with the 72-hour notification deadline? And again, this is a yes, no, don't know question. This is an issue that information about a breach may come into a company, into an unusual place within the company, or somebody might not recognise that there's something that needs investigating. So companies do need processes in place to be able to effectively triage information that may relate to a breach, escalate to the appropriate level within the business, and come to conclusions as to whether it is a notifiable incident or not, within a strict and frankly difficult to comply with time frame. It is important to have those processes in place, and certainly pre-GDPR we have seen issues with clients where information which arguably was sufficient that the company had noticed for a breach wasn't sort of identified and escalated quickly. Pre-GDPR, obviously that was less of an issue. Post-GDPR, it obviously brings into play an additional head of fine or regulatory action for failing to notify within the stipulated time period. And moving on then to the third polling question, do you ensure that internal or external legal are involved immediately in any breach investigation so as to preserve privilege as far as possible? Again, this is a yes, no, don't know question. There are sort of grey areas, and it will be fact-specific in some situations as to the degree to which you can argue that privilege applies to the investigation after a breach. But we will be very clear, and this is following the US model, a sort of much more mandatory breach notification and data subject class action, that every step possible must be taken to preserve privilege in relation to both the investigation and any forensic IT or cybersecurity consultant's report. There is a much higher risk now of significant fines and or class action after a breach. So at least if you've got an argument that privilege applies into investigation materials, you can have that fight later on if you need to as to whether privilege is effective and does apply. But if appropriate steps weren't taken to involve either internal or external legal function as appropriate, you don't have that argument. The material produced isn't privileged, and that can be extremely damaging to the ability to actually either respond to regulatory enforcement action or deal with a claim from a class action claim, which could be very high value from disgruntled data subjects. So just waiting for the results of the polling to come through. Hopefully the technology is going to work. If there are any other questions that people have, obviously please submit them in the usual way, and we'll try to come back to people afterwards. I appreciate this has been sort of a fairly high-speed run through what's quite a broad topic, and obviously I picked up certain specific issues in relation to where we might see the ICO go on enforcement. I would recommend looking at the ICO NCSE guidance, but there is a whole raft of other guidance on the ICO's website about their approach to security. So, for example, security for small businesses, what issues around encryption, issues around use of cloud computing. There's specific guidance in a number of areas, much of which is fairly old now and would hopefully be updated post-GDPR, but it's still useful guidance that should pay attention to and hopefully would give a good answer to the ICO if that guidance had been followed. So just picking up the results of the polling questions. First question, are you concerned about the status of other GDPR compliance if you did have to notify a breach to the ICO? That's come in as yes, 29%, no, just over 19%, maybe 51.6%, 52%. I mean, no company is compliant at the moment, to be honest, or very few companies are fully compliant with GDPR. It is a risk of the spread of investigation, so it's one to consider when looking at what is the risk after making a notification. Just being aware of it is something that an investigation might broaden out into. Question 2, are you comfortable that you've got appropriate systems and controls in place to identify a breach within 72 hours? Good result here. Yes, 57%, no, 17%, don't know, 26%. For everyone there, I would suggest doing some sort of tabletop exercise or testing those processes at least every sort of few months, 6 months, is a good thing to do. And perhaps sort of throw in unusual ways of information about a breach coming in just to test within the business whether those are actually applied or not. Third question, do you ensure internal or external legal are involved immediately in any breach investigation to protect privilege? Again, a good response on this, and 79% saying yes, 8% saying no, 12.5% saying don't know. It is really, really important in the post-GDPR world to get this right because there is a much bigger risk to the business, both higher fines and of class actions. And we already know of firms gearing up to bring class action claims in the same way that they're brought in the US after data breaches, and litigation funders are looking at funding those claims. So it is going to be a developing area where, I mean, risk could perhaps even be greater than on the regulatory side. Anyway, that was all we had time for, and we've managed to rattle through everything we wanted to cover. So thank you very much, everybody, for dialing in and for listening. If you do have questions, please submit them and we'll try and get back to people. The next lot of content will be uploaded onto Global Data Hub next month, and obviously we will let people know about the next webinar when that is planned, so everybody can put it in their diaries and hopefully dial in again. Thank you very much.
Thank you.